In the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online on our civil docket. And up next, we have an administrative appeal, Lowry v. Michigan Unemployment Insurance Agency and Michigan area, well, in the Sheboygan schools. It's filed 26-9188AE. And are you Mr. Lowry, sir?
Yes, sir.
Okay, Mr. Lowry is present with us in the courtroom. Counsel for defense, you want to place your appearances on the record?
Good morning, Your Honor. Assistant Attorney General Tara Brin for the Unemployment Insurance Agency.
And Roy Henley on behalf of the Sheboygan area schools.
All right, good morning. Mr. Lowry, you have noticed up a motion for a change of venue.
Yes, sir.
You want to go ahead and tell me anything you want in response to or about that motion?
Well, in my motion, I made reference to the last hearing we had in this court between myself and the school and the unemployment agency. And I explained that the court didn't seem to be interested in my part of the claim because I was a pro se. I guess I inferred it. And
yeah, I assure you, I didn't say anything of the sort. That I treat people who are representing themselves no different than people who are represented by an attorney. If they have a valid claim, they'll win. There are people who represent themselves who win in this court. So I assure you, that's not the case. But go ahead.
well, and then after the beginning, you came out with the statement that school bus drivers have never drawn unemployment. And if they want extra income, they should take a summer job or just stay home if they'd like. I guess that's where I added to it. So, and through the case, you had said that you read my documents or reviewed them, I guess maybe the proper word. And one of the things that began this action was the fact that the Sheboygan schools had threatened school bus drivers, Marlene Alexander, that if anybody drew unemployment, they would, Marlene Alexander said she would fight it. And that was in September 2019. In 2020, I didn't apply for unemployment, but I applied for in 2021. The school had written in their contracts that if an employee received unemployment benefits at the end of the year, they would reduce their hourly rate the following year. And which is against the Mesa Act to make that type of a statement.
You're sort of arguing the merits of your appeal, which we'll get to in a minute, but I'm interested first in your motion to change venue. If we can.
Well, that's my change of venue is because I haven't seen where a school employee can receive a fair case or hearing in Sheboygan County Courthouse.
For what reason would they be unable to obtain a fair hearing in this county?
Well, in your case, I base it on bias, and Judge Barton's case was an interested party in the case, and she lied under oath, and then she sealed the transcript.
What's my alleged bias that you're claiming?
Well, to say that school bus drivers have never received unemployment benefits, but in my brief, I brought up the fact that in 1972, the federal government awarded school employees unemployment. And so yes, they did receive, and actually, in 2020, our female bus driver received unemployment and was not denied, and that was in the brief, and you wouldn't even address that issue, which is the civil rights violation of gender discrimination, and which was a good part of the complaint. It should have been, I mean, I was amazed at the court. Well, I can't say I wasn't amazed because that continued on afterwards. They just, the powers to be just kept ignoring the civil rights violation.
Okay, you have filed a document that says appellant's response to appellee defendant's legal counsel's responses.
Yes.
But they haven't filed any responses. I don't have anything in the court file that they filed any legal arguments yet. So what are you responding to?
Well, I received a response from Henley and a response from Corinne.
In this appeal?
Yeah, I have them here and I responded to them.
Your Honor, if I may clarify.
Yeah.
The Michigan Unemployment Insurance Agency did respond to his change of venue motion, but that's the only thing that we have responded to. It was with the our request to appear remotely.
And Your Honor,
yeah, I never.
Sheboygan area schools did the same thing.
Your Honor, I'm happy to email that over if you'd like.
Well, yeah, we never received, we got your appearance. We got the appearance from you both. We got the request to appear by Zoom. We did not get a response from either of you to this motion. But I mean, I don't know that it's necessary. Go ahead, Mr. Lowry, and finish up anything about your motion to change venue.
Well, in their response, they don't want to go to a change of venue, or they said that they brought up, well, the act goes to circuit court for convenience of the parties. Well, in our last case, the defendants didn't show up and the attorneys showed up on TV as they are today. And, you know, I don't read where that is due process by doing something like that.
All right, is that it?
Well, I have my response to theirs. You did receive a response?
I got your response to theirs saying that, yeah, complaining about a lot of the past case, including saying that there was no transcriptionist in the courtroom. Well, we maintain a video record, video and audio recorded record. And if you want a transcript, you can order and it does get transcribed. That's how it's done in many courts throughout the state these days. We don't have an old-fashioned court reporter transcriptionist in the courtroom, no. But a record is still properly being made.
Well, I ran through quite an experience through the appellate process where the recordings were edited, and actually the appeal was edited before they went before the ALJ judge. So that's why I was concerned about transcription. It seems to be very easy for a recording to be edited before it gets to the transcriptionist, and I found that to be true. And that's why I'm concerned about recordings.
All right, anything else, sir?
And, you know, sitting in this courtroom and they're on the TV and there's no defendants, as it's happened before, I feel like it's a show trial to me. And hang
on, Mr. Law, in what conceivable way is it a show trial, whether they're sitting at that table making the arguments or making the arguments by video conference, which is authorized by court rule of the Michigan Supreme Court? How is that a show trial? Well, they're going to make arguments the same way.
I have no in-person of either party contact or discussion
right,
available to me.
All right, thank you. I don't need to hear arguments from defense. Your motion to change venue is denied. Mr. Lowry wants to litigate this case like it's 1978 and have a transcriptionist and no video, and that's just not how it works these days. You get a fair trial like everybody else does. And I'm not biased against women as you, or against men, bus drivers, as you've alleged. That is a huge leap. Just because I denied your appeal last time, you think I'm biased against you.
You didn't even bring it up.
That is untrue. And you will get a fair hearing in this court. You have done nothing to demonstrate that I am biased and should be recused, or that this should be changed to another county or a different judge, other than wild conspiracy claims that I'm not even going to credit them by reading them aloud on the record today, comparing this courtroom to other things throughout history that is offensive. The motion is denied. All right, and the court will prepare an order to that effect. Now, you also noticed up this appeal, but that's not proper yet at this point, right? You got to get the record filed and we got to get the briefs filed, right?
I filed the claim and I almost have the brief done.
Okay, but the brief's not done. Okay, so counsel, just like last time with an administrative appeal, Mr. Lowry, you've got to make sure that the record on appeal gets filed. You can contact, Ms. Bryn about that and see what the status is on that. But as the appellant, you've got to follow those rules, which you did last time. We got the record filed and the briefs were filed. Then I schedule it for oral argument. That's what we'll do this case. So you've got to follow those court rules about getting the record filed, and then you file your brief, then they file theirs, you file a reply, then I'll schedule it for oral argument and we'll have a hearing. All right.
Do I have a timetable to file the brief, sir?
Yeah, there are timetables under the court rules that you have to look up if you're going to represent yourself and follow those court rules. Ms. Bryn, anything from the Attorney General's office today from unemployment agency?
No, Your Honor, but I would just like to make for the record that there is a pending Sixth Circuit Court case also with Mr. Lowry regarding the same parties, similar issues. And while it's a different claim, I think some of the information covers a number of claims. I just wanted to make the court aware.
Okay, thank you. Do you know what the status is on, has Mr. Lowry ordered the record?
Your Honor, not that I'm aware of, but I am happy to reach out to MOAR and ask if that has been, but usually we do get notice and we have not gotten notice of it.
Okay, so Mr. Lowry, just like you did last time, there's a process where you have to order the record so that it gets filed.
I did, sir. I have. And I received simple sets of documents and they haven't complied, as in the last time you denied me transparency of the case. And the UIAC denied me oral argument.
All I see is you filed a claim of appeal and then this motion to change venue. You haven't filed any proof that you have requested the record. I mean, you did it last time.
The proof that came from the UIAC.
Right, but you're wanting to appeal from a decision of an administrative agency.
I understand.
Before I can review that decision, I have to have the record to review it. And
last time I gave you the copy of the decision and the UIAC sent you a copy of the record. They did not provide me with a copy of the record. They won't.
Right. Well, you need to review the court rules for prosecuting an appeal on your own behalf and follow them so that you can get that record filed. If you want to reach out to Ms. Bryn, maybe she can help you with that. I don't know what her willingness and availability is to do that, but I got to get that record filed. Once that record is filed, then there's deadlines. Then the clerk's office sends out a notice to everybody that we got the record. And then the deadlines for the briefs are triggered then. There's a whole schedule and it is set forth in the court rule.
Yeah, that was provided by the UIAC last time.
All right, Mr. Henley, anything further from the schools? Hold on, you're still on the record.
Thank you, sir.
All right. All right, thank you. So the motion is denied and we'll await the further proceedings on the appeal. And Mr. Lowry, if you don't follow those court rules, I guess what would happen is then the clerk's office would issue some kind of notice that you have failed to prosecute the appeal and give you notice and a deadline before it would be dismissed. But so you've got to make sure I get the record and then the briefs get filed after that. Okay. And then I'll give you a fair hearing. All right. That'll take care of this case.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.